Okay, hello everyone. I'm Katie Glenn Bass. I am the research director at the Knight First Amendment Institute, where we focus on defending the freedoms of speech and the press in the digital age. Thank you very much for being here with us. This is the first in a two-part webinar series that the Knight Institute is hosting on chilling effects. Chilling effects are an important concept in First Amendment law, but they're also a very complex one. And chilling effects are all around us right now. You've probably seen commentators comparing our current moment to the Red Scare. And this is really sort of what we're talking about when we talk about that, is the chilling effects that we are all feeling. So we're going to get into that. This one is going to be on litigation, on trying to get into court to challenge laws or policies that involve chilling effects. And then we're doing another one on December 10th. We will put a link in the chat to sign up for that if you're interested, on studying chilling effects. So how you try to establish or prove that a chilling effect is taking place in a given moment. And we have today really the best speakers you could hope for to talk about this sort of concept. I'm going to introduce everybody in alphabetical order briefly. First off, we have Carrie DeSell, who is my colleague at the Knight Institute. She is a senior staff attorney and legislative advisor. And her litigation focuses on freedom of speech on social media, government surveillance of speech at the border, and digital age threats to freedom of the press. We also have Evelyn Dueck, who is an assistant professor of law at Stanford Law School and who was a senior research fellow at the Knight First Amendment Institute from 2021 to 2022. And her scholarship focuses on online speech regulation, content moderation, and platform governance. And she is working on an article right now, which has not been published yet, but I've read a draft and it's great, on the doctrine around chilling effects. So we're going to talk to her about that in a little bit. We also have Stacy Livingston, who is my former colleague at the Knight Institute. She is now a clinical lecturer in law at Yale Law School and a Craig Newmark Fellow at Yale Law's Media Freedom and Information Access Clinic. And finally, we have Jonathan Penny. John feels like a colleague of mine because we have done so much work with him and continue to. He is an associate professor at Osgoode Hall Law School, where he holds the York Research Chair in Artificial Intelligence, Data Governance, and the Law. And he is the author of Chilling Effects: Repression, Conformity, and Power in the Digital Age, which is a book that is now available from Cambridge University Press. And it is being described by reviewers as the authoritative or definitive work on chilling effects. So we are lucky to have this group with us today. I'm just going to say one thing to the audience about Q&A. We will have dedicated time towards the end for Q&A, but you can also submit your questions at any point during the discussion. I'm going to keep an eye on it throughout. And if I can find a moment to work in a question, earlier in the discussion, I am happy to do that. And when you submit your question, if you want to add your name, you can. I know we have many people that we all know and have worked with here, but you don't have to. It's up to you. Okay, so thank you all so much to our speakers for being here. I'm going to start off with John. I just want to establish, a baseline understanding for everybody is here. What is a chilling effect? What are some examples, and why is free speech concerned with these?
Great, and thanks, Katie. First, I want to say thanks to the Knight First Amendment Institute for the invitation to be here, and it's just great to be on such a fantastic panel. Looking forward to a great conversation on point. So, what are chilling effects? Why do they matter? How do they manifest? In ways, what we're seeing today is really chilling effects happening in real time throughout society, right? So when I was finishing the book in April, and you write the introduction last, right? I was just scanning the media and the news stories and what was happening. And just in April, there was a series of these stories all just at the same time. You had Mahmoud Khalil, an American permanent resident, who was arrested and rendered to a secret facility by the US federal authorities for promoting and engaging in university campus protests at Columbia University. You had a member of Congress calling for the FBI and the DOJ to criminally investigate protests at retail locations of Tesla, a business owned by one of the world's most wealthy and powerful men, Elon Musk, who at the time was also one of the most powerful men within the US government, heading on the Department of Government Efficiency, then DOJ. You had a US attorney based in Washington, D.C., sending target letters and threatening to send target letters to anyone who obstructed or even protested the work of that same government agency, which at the time was secretly acting in a very secretive way, dismantling important government infrastructure. You had private sector data contractors signing contracts with the Trump administration, conducting large-scale online surveillance to assist ICE, the federal immigration authorities, to track and map people's activity, movements, and relationships. Now, today, months later, we can see the resulting chilling effects of these kinds of profound threats, right? So, other than a few exceptions, protests about overreaching ICE and other federal government activities have been largely muted. Even Trump himself has said, wow, I'm surprised that the protests have been so muted in the country. Media companies like ABC and CBS have settled lawsuits and have modified their coverage of the Trump administration as a result. Journalists have also reported changing their coverage, fearing blowback and retribution. Law firms that during the first Trump administration launched a lot of the key lawsuits that held the government to account have declined, fearing being targeted. And some of them have been targeted by Trump and federal actions. And many universities, maybe most universities, have acquiesced to federal demands, including altering speech rules. This is something that Evelyn has talked about in her important work on Point. And of course, social media companies too. Lining up behind the Trump administration, many attending the actual inauguration have also altered their content moderation rules. So we're actually seeing in real time chilling effects happening within society. If anyone remembers the line that Adam Serwer's sort of famous line about the first Trump administration, that the cruelty is the point. The line that I've been using these days, I've been meaning to do an op-ed on Point, the chilling effects is the point. This is really, in my view, governance by chilling effects, using it in a very systematic way to repress speech and repress certain groups and to oppose any kind of action or any kind of actors, institutional, government, and society that would constrain the Trump administration. So now we're seeing this happening. How can we understand what chilling effects are? So really, chilling effects have this duality, this sort of dual nature, which I think actually leads to its complexity when it comes to litigating. So on the one hand, chilling effects is a legal concept, but it's also a social and behavioral phenomenon. So what is the legal concept? So largely the concept comes to us in US First Amendment law. We'll be talking more about this on this webinar. But it arises within American jurisprudence after the Second World War. We have a series of anti-communist statutes being enacted during the McCarthy era, and then later, of course, repurposed in the civil rights era to repress the civil rights movement. But starting in the post-war period of a series of US government, Supreme Court decisions where they develop essentially a doctrine and invoke this concept of chilling effects in order to scrutinize these overreaching statutes and in some case strike them down. Now, underlying that concept is this notion that people will self-censor their First Amendment protected speech out of fear of some legal harm that's attached to a statute, right? Legal punishment, jailing, or civil penalty. And they do so out of uncertainty, uncertainty as to the scope of these laws or uncertainties about the legal process. And so they self-censor. In my book, I call this sort of the conventional view of chilling effects. What I talk about also in the book is understanding chilling effects as a social and behavioral phenomenon. That is, chilling effects is a behavioral response that's actually deeply ingrained, and I'll talk a little bit more about that in a few moments, to a perceived threat to personal safety, be it real or imagined. So people self-censor and the research shows engage in conformity as a means of self-protection, right? To avoid the perceived danger or to avoid the perceived threat. So they don't speak and remain silent to avoid the legal harm or the other kind of threat that they face, but they also engage in kinds of group conformity. And that's also a mode of self-protection too. There's strength in numbers. And the best way to understand this behavioral response is in light of this vast social scientific literature on threat response, right? And this response that we have to threats likely has grounding in evolutionary psychology. So historically, people who engaged in self-censorship and in group conformity in the face of threats were more likely to survive. So actually, chilling effects as a legal response, but as a behavioral response to threats, is actually likely deeply ingrained. Why that matters, it means that sometimes, in the face of, say, an overly broad law enacted by a government, we will rationally decide to stay silent, to avoid the legal threat or the threat that is posed. But also, it means that we can be chilled and we'll self-censure and we'll alter our behavior in automatic and sometimes subconscious ways. And that can manifest in something more subtle, where we subtly change our behavior. We're less likely to attend a rally or to protest, or even in some cases, just simply visit a website to inform ourselves about important information about matters of public interest and policy. So chilling effects can manifest as self-censorship, conformity. Also, at larger scale, it can manifest in forms of what I call institutional avoidance, where people who have been systematically targeted or members of groups that have been systematically targeted avoid institutions within society, which form part of broader government or surveillance apparatus that they fear information about them might be shared or exchanged. And the threats that can cause these kinds of chilling effects can be laws. They can be targeted prosecutions. They can be surveillance. They can be also personal threats of violence and cyber mobbing, as some of my colleagues like Daniel Citron have documented in this context. And in the book, I actually talk about different factors that go into what causes the most profound forms of chilling effects. And that includes what I call the chilling effect factors, right? So observation or surveillance, uncertainty, and you often have that with uncertain and overly broad laws, forms of personalization. So when laws have been enacted to specifically target certain groups, like women in the case of abortion restriction, in the case of sexual minorities, in the case of recent anti-LGBTQ, anti-trans policy actions have been taken throughout the United States at different state, federal, whatever levels, they can have a really profound effect. And lastly, the fourth factor is power and authority. So those actors that have power, both private power, power that can rule technology, or state power, that's another key factor. So actors with more power, the resulting chilling effects are more profound. And those actors, like states and governments that can actually wield all of these elements or factors, observation, uncertainty, personalization, and power, can have the most profound chilling effect. And you see that happening in society. So let me finish with why this all matters, right? Why are we even talking about chilling effects today? So first, of course, we lose on an individual level, we lose valuable speech. We lose protesting speech, dissident speech, creative speech, innovative speech. We lose speech that would speak out about the harms of deeply repressive government policies or people who would speak out against unjust wars. We lose that, and all we have is silence, and the general public is less aware, and members of communities are less aware to protect themselves about the threat that's out there. When it comes to surveillance, both on an individual and broader level, it has an impact on each of our creative and willingness to sort of push the boundaries of social norms and other creativity. Julie Cohen has a great line where surveillance and the threat of surveillance leads to a dullening, where we moderate our behavior and engage more in conformity. We lose to creative self-expression, self-experimentation that's so important to personal development as we develop as people, as identities, as we share and experiment with people on an interpersonal level, but within our groups, communities, and broader society. And also, when you have more targeted examples of groups and individuals who've been specifically targeted and have disproportionately been targeted in the past, can have really profound effects. People leave their jobs, they leave their careers, they stop engaging online entirely. And it can have a really profound effect on people's lives, not just losing speech, but losing their way to live on a day-to-day basis. And then we finish with the effect on a societal level, which I think we're seeing within the US today, with the effects of actions at the state and at the federal level. You have chilling effects on a mass scale. And something that I actually tracked empirically in my study on Wikipedia before and after the Snowden revelations, where people, when made aware of the potential being surveilled or watched online, were less willing to simply inform themselves by accessing content on Wikipedia, nothing that was illegal, nothing that was controversial, but were willing to avoid what they perceived as content that might be tracked by governments. And so therefore, we're avoiding or being chilled from informing themselves about important matters of public policy, including national security and anti-terrorism elements. And you can see, of course, with the Trump administration today, the effects in society, the muted protests, all of that. And lastly, The other element of this is group conformity. And when you talk about that at the societal level, you lose or you undermine and you erode deliberative democracy. It's so important to have creative speech and dissenting speech. It's important that people, to inform the general public, can speak up about the harms of state actions. And if you lose that, you lose those profound effects. But the other element of this, we often think of conformity as people being more muted or behaving in a way that's more courteous or quiet. But conformity can also lead to more extreme and polarizing behavior. And I think you're seeing that too. So chilling effects can also lead to more extremism in society in the same way it can lead to silence. So for all those reasons, it's really important for us to be thinking about and litigating about it today.
That's great, John. Thank you for that excellent overview. And I will say, having read his book, it is just as nicely articulated and easy to read as that presentation was. And I think, it's a really important point to get out there. This conformity, like chilling effects and conformity are closely related, but they're not exactly the same thing. They are all sort of, talking about this negative space in some ways, these things that are not happening, these things you're not saying or not advocating for or not doing. But conformity operates, more at a societal level in some ways. And also, I think it's a great point that conformity doesn't necessarily mean, hieing over to the middle ground view. Sometimes it can be your perception that others hold these extreme views, so you also need to express these extreme views.
Precisely, precisely.
Okay, so we're going to get a little later into the difficulties of trying to show that negative space, trying to show those chilling effects. But right now, I want to turn to Evelyn and ask if you could please give us an introduction to current Supreme Court doctrine about chilling effects and sort of how they treat these sorts of claims as they come through. And I'll just remind you, you're muted. There you go.
Great. Okay. So I guess the first thing to say is that the First Amendment talks a really big game when it comes to chilling effects. There's all these extremely lovely quotes and beautiful language about how much the doctrine acknowledges and cares about chill, alongside direct speech suppression. So the cases tell us that the First Amendment freedoms must be protected not only against heavy-handed frontal attack, but also from being stifled by more subtle governmental interference, because they are delicate and vulnerable and sensitive and of transcendent value and supremely precious. The cases say that inhibition as well as prohibition against the exercise of precious First Amendment rights is a power denied to the government, and that for this reason, because of chilling effects, in an oft-quoted refrain that Chief Justice Roberts repeated just a few years ago, First Amendment freedoms need breathing space to survive. So there's all this great language about how much the First Amendment cares about chilling effects. The second thing to note, however, is that there's sometimes a bit of a gap between this majestic language and the reality of the ways in which the doctrine protects against chilling effects. But to describe this gap is actually a little bit tricky, because the term chilling effects, as ubiquitous as it is, and sometimes we talk about chilling effects doctrine, I think that's a little bit of a misnomer. There is no one doctrine. Instead, chilling effects shapes First Amendment law in lots and lots of different ways. So it can describe a First Amendment injury that gives plaintiffs standing to sue. So as I'm sure we'll be talking about, if you can show chill, if you've been chilled, that can give you standing. That's a First Amendment injury. It is also the reason why we have the exceptional First Amendment doctrines of overbreadth or the First Amendment vagueness doctrines as well, because of concerns about chilling effects. It also shapes substantive rules that the First Amendment crafts. So direct constraints on government actions that create chill, but also the mens rea standards that the court fixes in certain areas of unprotected speech. So most famously, defamation law, the actual malice standard. In New York Times v. Sullivan, the court talks a lot about chilling effects and that being one of the reasons why that standard is necessary. So what that means is that this heterogeneity means that it's difficult to describe the role of chilling effects in First Amendment law. And this difficulty, I think, is compounded by the fact that there's actually been great variation in the role that chilling effects has played in First Amendment doctrine over time. So as John was saying, chilling effects really came to the fore during the Warren Court era in the 60s and 70s, and I think was the primary engine of First Amendment innovation in response to the Second Red Scare. But then this was dramatically constrained and reined in by the Burger Court in the following decades. And then frankly, the Roberts Court's kind of a little bit all over the place when it comes to chilling effects. So it took the chilling effects of a donor disclosure law extremely seriously in AFP v. Bonta. But it was pretty blasé about chilling effects of government surveillance of communication in Clapper, or even last term of internet age verification laws in Free Speech Coalition v. Paxton. And so I think it's, again, difficult to describe sort of where we stand, given I think the court itself is a little peripatetic about this. And so I'm happy to go more into sort of those particular examples or those particular cases in the Q&A if people are interested. But for now, I want to make two sort of more general points about chilling effects. So the first is that what this history shows, I think, is that the role of chilling effects and the role that they do and should play in First Amendment doctrine is actually deeply contested. And this is because for reasons that John was alluding to, but it's quite hard to demonstrate and conceptualize chill. And also quite hard to work out exactly where we should draw the line when chill is severe enough to raise First Amendment issues. Almost any government action, almost any action of a person in power could and might create chill. And there are also certain ways in which we intend to create chill that are socially beneficial, that we want to chill certain points of view in society and sort of put them on the margins. And so all of these sort of various factors make it very difficult to work out exactly normatively, theoretically, where the line should be. What this means, though, is it can be very confusing for courts and litigators to work out exactly what the doctrine is and should be. And then the second more general point I want to make is that chilling effects doctrine is necessarily in constant evolution because the role that it plays, I think, is a defense against innovative ways that the government tries to silence speech. So let me sort of describe this dynamic. When the court first developed modern protections against direct censorship, this didn't mean that the government just sort of gave up and thought, okay, we're no longer going to try and suppress speech. Instead, as during the Second Red Scare, what happened was the government tried to chill speech through these indirect methods like loyalty oaths, disclosure laws, investigations, etc., as people are learning about these days in all of the coverage and commentary that's drawing the analogies between that era and ours. And so chilling effects doctrine was the court's response to this. It's like a cat and mouse game. So the court develops protections against direct censorship. So then the government says, okay, we're going to try and indirectly censor and chill. And then the court goes, no, you can't do that either. We're going to develop protections against indirect censorship. But of course, the government doesn't stop innovating. It doesn't go, oh, okay, court, you win. That's not how this works, as the Trump administration is demonstrating right now. The speech suppressive government actors will look for new ways to chill speech. And so it's a testament in some way to the strength of the First Amendment protections against direct censorship that chill is the primary form of speech suppression employed by this administration. As John said, the chilling effects I'm never sure which to use, are the point. But it means that, but they look new. They won't always be the same methods, the same tools of chill that have been used in prior eras. And this means that litigants and doctrine can't stay static either. It necessarily needs to respond to these new innovations in speech suppression. And so that's, I'm sure, what we're about to be talking about and what we're seeing in the cases today. And so far, lower courts have been recognizing these attempts to work around the strictures of the First Amendment for what they are. Because at its root, what chilling effects doctrine is, what it was developed to be, was the recognition that there are many ways for the government to suppress speech that don't look like the Sedition Act or other forms of outright censorship. And it recognizes that if we are to truly have the uninhibited, robust, and wide open public sphere that First Amendment doctrine promises us, then the law also has to protect against these indirect modes of speech suppression and recognize the subtle ways that government power can be wielded to make people stop talking. And so it's this constant back and forth, this constant cat and mouse game, and this constant evolution, which is why it's really exciting to see the innovative ways that litigators are bringing these cases now.
Great, thank you, Evelyn. Yeah, so I want to bridge now to some of the cases that are actively happening, and I think one way to make that bridge is we're going to talk a little bit about standing. And Carrie, I think I will start with you here. So standing at its most basic is just the right to bring a lawsuit in court, but standing is also, sort of the plague of First Amendment chilling effects claims because it can be quite difficult to establish standing in cases involving chilling effects. So Carrie, do you? In your many years of litigating these cases, having worked with you, I know that this has given you more than one headache. So you want to talk a little bit about standing challenges in this area?
Yes, thank you, my bête noire. So, yes, standing, as you described, is kind of the right to get through the courthouse doors. The doctrine requires a concrete and particularized injury that is uh, either current or imminent, and that is caused by the action that you're challenging and redressable by a favorable court ruling. That's a synopsis of the standing doctrine. I mean, ironically, as Evelyn kind of addresses in some of her work, I mean, standing was one area in which the Warren Court tried to create some flexibility so that First Amendment challenges could be brought by people who are perhaps not directly targeted by the challenged regulation, for example. But over time, that doctrine has gotten increasingly restrictive to the point where now, with a few exceptions, it seems as though the court doesn't have any particularly special First Amendment doctrine of standing. It just applies generic standing rules to First Amendment cases, notwithstanding, excuse me, the the particular values that the First Amendment strives to serve and the particular challenges in bringing First Amendment cases for many of the reasons that John and Evelyn have discussed in their work. So I'll just touch on two of the cases in which this has been, an issue for us, but I will end on an optimistic note. So to start with, I'll mention our Doc Society litigation on behalf of two international documentary filmmakers who challenged the first Trump administration's requirement that visa applicants disclose their social media handles on their visa application forms. And so this, has many of the factors that John described with respect to chilling effects. It's oversight, it's surveillance. So you're providing your social media handles to the government so that the government can then look at your speech on social media in deciding whether or not to give you a visa. Kind of more perniciously, the government then holds on to that information after you're granted a visa and come into the country for what once were unknown purposes, although unfortunately I think they've become clearer over time. This requirement is obviously wielded by a very powerful actor, the US government, and involves a lot of uncertainty. I mean, what speech would give rise to a negative determination on your visa application? Again, during the first Trump administration, it was actually harder to articulate what kind of speech would be problematic because we believed we had really robust First Amendment protections against the use of political viewpoint as a negative factor in government decision making. So in that case, as I mentioned, we represented two international documentary film organizations whose members included many people who were going to be applying for US visas to come to the United States, either to participate in film screenings or collaborate with US partners or attend school or work here. And many of those members were already in the United States, who would then leave to renew their visa or apply for a new visa from abroad and therefore be subject to this requirement, which gets into a whole nother legal wrinkle that I won't get too far into here. But the real question is whether or not this disclosure requirement created such a discernible chilling effect on the speech of these applicants, visa applicants, that it was kind of recognizable by the court and would open the courthouse doors to these cases. And in our case, the court did initially say, yes, you have standing. It is clear and you have alleged sufficiently that these members are stopping their speech on social media. Many of them deleted their social media accounts because they wanted to be able to come to the United States or stay here to continue their work, or just stop speaking on controversial topics. So it fell within one particular kind of case. I'm just going to flag this case because it's really significant in this context, Laird v. Tatum. that kind of distinguished between what it considered to be subjective chill. So describing government action that in that case was reported to be occurring. Kind of, there was a report that there was army surveillance being conducted of protesters and other civic institutions, and so thereby chilling the speech of those institutions and the willingness of people to join them in their efforts. But the court concluded that it was speculative that there was any harm at the end of that reported activity. And then in Clapper v. Amnesty, another big case in this area, the court said, notwithstanding your awareness that there's a surveillance program in place, it's speculative, despite a lot of kind of empirical evidence, that the plaintiffs in that case would be subject to that surveillance, so they couldn't show the harm. So anyway, we got over those hurdles in Doc Society, only to get to the point where the court concluded that our harms were not redressable because effectively the chill was overdetermined. There were so many bad factors involved. I mean, so many potential consequences to speech on social media that it would be almost foolish not to be chilled on social media if you were seeking a government benefit at this point. So we're still working through those wrinkles. I just want to end, more briefly on a much more optimistic note, which is our case in AAUP v. Rubio, representing AAUP, the American Association of University Professors, and MESA, the Middle East Studies Association, and a challenge to the government's policy of arresting, detaining, and attempting to deport people based on their pro-Palestinian speech in the United States, and specifically targeting students and scholars in the United States. And there, the court concluded that the plaintiffs had established a real chilling effect such that their claims were cognizable in court, that they could go through and proceed to the merits. And then based on really extensive evidence developed through a 9-day trial and many courageous witnesses who actually were willing to take the stand, the court concluded on the merits that the really dramatic chilling effects in that case represented an unconstitutional infringement on the plaintiff's First Amendment rights. Okay, thank you.
Thank you, Carrie. I'm going to stay with you for a second on those two cases before we hear from Stacy. So in terms of the differences between those two cases, in terms of what you were able to show that a chilling effect had taken place, can you talk a little bit about that? Like, what evidence was available to you?
Yeah, I mean, this gets to a really tricky point in these cases, which is that when people are exposed to really significant consequences for their speech, it requires a tremendous amount of courage to stand up in open court and attest to the fears that stem from those consequences, to the chilling effects that the court requires for you to proceed with your First Amendment claims. And we try to explain that in the Doc Society case, saying that many of the in fact, all of the members that we spoke to were unwilling to be named in the litigation, particularly at that point, because the thing they feared was government attention to their speech on social media. And so to litigate against the government based on what you want to say on social media is almost nonsensical. But in the AAUP case, I just have to credit the incredible team in that case and our incredible plaintiffs and their members for demonstrating such courage to really stand up on behalf of their other members, more vulnerable members perhaps, and the many witnesses who did come forward and say, I'm a non-citizen and I have stopped speaking, I've stopped publishing, I've stopped going to protests, I've stopped engaging with students on particular topics because I fear government retaliation for my speech. And yet I believe so strongly in this case that I'm going to stand up. I will note that Judge Young in that case entered a protective order prohibiting the government from retaliating against these witnesses based on their testimony. And that was incredibly important there as well.
Yes, and as I understand it, it's fairly rare for a judge to order that sort of protective order for witnesses in a case like this. But I'll also underscore, I mean, just in terms of the moment we're in, those witnesses had to rely on the effectiveness of that protective order to testify against a government that is not especially interested in court orders these days, unless really put to the test. But that, I mean, that is one of the big challenges, I think, in these cases, is you have to have people who are willing to speak out, and you also, you can't just argue this is chilling other people because they're not speaking. They're not saying that. You have to be able to offer more than that. But the more than that is hard to come by sometimes and hard to know exactly what to say. So Stacy, I'm going to turn to you now. So this case that Stacy is about to introduce us to, the short name is the United Auto Workers versus the Department of State. And I will say, when I saw the press release when you all filed this case, I had a moment where I was like, God, that's a great effing case. Like it's just so it's so nicely put together. So why don't you tell us a little bit about that? What is it about?
Sure. Well, before I jump into the specific details of the case, I'll just say I feel very fortunate to get to benefit from all of the discussion because the case is so new and we do still have an opportunity to make changes and to adjust our approach. So very receptive and open to feedback on what I'm about to say. Our case was filed in mid-October, and our team at the Media Freedom and Information Access Clinic, as well as ESF and Muslim advocates, filed a lawsuit on behalf of 3 international labor unions and their members to challenge what we've been calling the Challenge Surveillance Program, also workshopping a better name for the Challenge Surveillance Program. But the program is an interagency federal program that the administration is using to surveil non-citizens, detect disfavored expression, mostly online by those non-citizens, and to very loudly use that disfavored expression to revoke their visas or otherwise terminate their immigration permissions and throw people out of the country. We benefited hugely from the evidence that was developed in the AAUP versus Rubio trial in alleging what we believe to have been the early iteration of the Challenge Surveillance Program, which was mostly focused, it seems, on student protests and speech that was supportive of the pro-Palestinian campus movements in spring 2024. But based on the government's recent statements and a lot of really great news reporting, we understand that the scope of the Challenge Surveillance Program has expanded substantially since that time, in at least 3 significant ways. So first, although it seems that the surveillance going on in the early iteration was fairly manual, the administration is also using really advanced technologies, including, it seems to be, some AI programs to surveil all non-citizens present in the United States to try to detect these disfavored views. It now requires everyone who applies for a visa to make their social media accounts public and to keep them public. And the punishment for not doing that is that the visa office says that they will make an adverse assumption about your application and your honesty if you do not have public social media. And then third, the administration is also apparently looking for way more categories of disfavored expression than simply pro-Palestinian advocacy. It is also looking for all of the things that it name checks in Executive Order 14161. That includes anti-American speech, whatever that means, speech that is deemed to be sort of adverse to the unspecified national interest, as well as hostile attitudes toward government or to American culture. So it's an incredibly broad list of expression that could sort of draw the ISR on to anyone who speaks it and drips these online censors. And we allege, and the sort of statements from our plaintiffs members really bear out, that this is having a massive chilling effect on the ways people are willing to speak and associate both online and offline. As sort of touched upon by some of the other panelists, it can be really difficult to prove chilling effect. And so the way that we've tried to do that in our lawsuit is that we worked with our clients to circulate a survey where we asked people anonymously whether they were aware that the administration was surveilling speech online by non-citizens to potentially use that for adverse immigration consequences. And if they were aware, that whether they had changed their online and social media speech in response to it. And the responses that we got to the survey were pretty staggering. They demonstrated massive chill by particularly non-citizen members of the unions who said that they had done everything from foregoing posting to deleting their accounts entirely in order to make it less likely that they would be swept up in this challenge surveillance program and trigger some of these adverse consequences. Another interesting thing that we saw, though, was that citizen respondents also reported that they had been chilled in many circumstances because they were afraid that if they spoke out, they would attract attention to non-citizens in their lives, family members, friends, colleagues, people who might have been implicated by their speech. And another third thing that we saw was that people were not only suppressing their speech online, they were also suppressing their expressive activity offline, including foregoing protests, and especially significantly for our union plaintiffs, they were pulling back in many circumstances from public affiliation with their unions because in some ways there's just no telling what will be perceived as disfavored, and any kind of public recognition, including sort of affiliation with labor advocacy, could be perceived as, bad and punishable. Our lawsuit also talks a fair bit about the coercive and threatening statements, the way that the Trump administration is trumpeting the instances where it is enforcing immigration consequences based on speech it's found. And our claims are based on the fact that the surveillance is itself a harm, but so is the amplifying effect of all of these threats. And as John mentioned, the chilling is the point. The administration is really saying, we're watching you, so you better shut up. And so, the fact that the administration is watching you is chilling, but the fact that it says it's watching and that you better shut up or else is also an independent aspect of our claims. So we've brought 3 APA claims and 4 First Amendment claims. We allege viewpoint discrimination, a claim based on the coercive threats, an anonymous speech and association claim based on the requirement to make your social media public, and also a listener's rights claim based on the chilling effect and the deprivation of the willing speakers for both unions and unions members. And I'm very happy to talk about any of the details of the lawsuit beyond that, but it's possible that my answer will be, I don't know yet, just because we are still waiting for the government to respond.
It is early days. Thank you, Stacey. In the complaint, I think the survey results that are included in the complaint are really very interesting reading, alarming reading as well. And I think the association aspect here is also a good one to draw out. I think we often think of chilling effects as things you don't say or even don't do, but it's also about like what groups you're willing to join or who you're willing to talk to or be seen talking to. So to give a sense of how sweeping it is. So that survey made me think about the use of evidence in these cases. And John, I think I'm going to ask you to start here, but I'd also love to hear from Evelyn and Carrie on this. As Carrie was saying, one way, a high hurdle, but one way to show a chilling effect is to find people who are willing to testify to that chilling effect. But, what other kinds of evidence can we draw on or do courts consider when they are looking at whether or not a chilling effect has taken place?
Yeah, it's such an important question, and I think when we get into some of the answers, just speaking to Carrie's experience and Stacey's experience, shows the complexities of this challenge. And maybe let's go back to actually something you had mentioned earlier in the webinar, Katie, where you had said when you're talking about a chilling effect, when it comes down to it, what it is, it's an absence of action, an absence of speech, a silence, right? And so how do you prove an absence, something that doesn't happen? It's in ways it's a counterfactual. You would say, how do you prove something that would have happened but for this state action, this like legal threat or surveillance threat? And that's really hard to show, right? How do you show that? Well, one way which you can do, which Stacey and others have shown, and I've done in my own research, is that you ask people, right? And you conduct a survey, you conduct interviews, you have also often qualitative examples of victims sort of speaking, describing how they've been affected by being targeted by a prosecution or some other kind of legal repression or threat. And the challenge even there with this kind of survey information is that there's often a lot of easy methodological challenges that are often raised, right? That sometimes we can't often trust what people report, self-reported chilling effects. And for someone who's representing the government as a lawyer, there's a whole battery of well-formed sort of legal arguments and methodological and social scientific arguments that an expert can raise to challenge it. I've seen my own research being challenged in the same way. I was ready for those kinds of arguments, but to a judge, it's 2 experts arguing, 2 ways on the same issue. And the other challenge with that kind of evidence, which is important and profound, and I think the evidence that Stacy has uncovered is really interesting and I think documents some very profound chilling effects. Is that when you look at the standing challenge that Carrie spoke to, is that what the U.S. Supreme Court has said about, for example, surveillance-related claims, right? That both in Laird versus Tatum, and then later in Clapper, claims that are self-inflicted are not going to be good enough, they're not going to be sufficient injury to get you to court. Claims that are too subjective, right? And the challenge, of course, is if you're asking somebody in a survey of how they've been affected by this law or government surveillance, it's the person describing how they've changed their own behavior. And the way the government, the way governments respond to that, and the way the U.S. Supreme Court, unfortunately, so far has been responding, and I'm very hopeful about some of Carrie's litigation to get over this hurdle, is that they say, oh, that's just a self-inflicted harm, right? That's not actually direct government action causing this injury. Instead, you're inflicting it on yourself, which to me actually doesn't make sense when you think about the fact that a chilling effects of First Amendment speech due to a overreaching law, for example, is easily accepted. It's a well-recognized, established First Amendment injury. But you can establish it with respect to a law which may not apply to you. That's the whole point. There's uncertainty as to whether it applies, so you self-censor. There's uncertainty as to awareness. If you have a reasonable case that you're targeted for surveillance, why is it so unreasonable? Why is that a self-inflicted injury and the statute chill is? So that's some of the challenges with the evidence that's out there. It's easier in other contexts. Now we have sort of digital media, which provides another way of documenting chilling effects. I've done in my research and others have done it, where you can show people's behavior pre and post. So if you can show, for example, an oppressive law that's enacted. So a recent study that I did with Danielle Citron and Alexis Short-Ingbar, where we looked at the effects of the Dobbs decision, which of course overturned Roe versus Wade, the constitutional right to abortion in America. And we looked at a chill on people's access of doing Google searches and Wikipedia searches. Likely women are being captured in this data, looking up peer tracking app. And there we found a chilling effect after the Dobbs decision. But those kinds of cases are really hard to find where you can document a chilling effect with data. And then even if you're able to, as Carrie's found, maybe the answer of the court is that the chill is overdetermined. That if we make this a cognizable injury, then we're opening the floodgates to too many kinds of claims. So fortunately, there is more ways of documenting chilling effects today, but it's still really difficult. And even in the cases that I've seen where you have that kind of concrete evidence, for example, I acted as an expert in Wikimedia Foundation against the US government in that litigation, and my evidence, my study formed part of the evidence. We still lost on standing due to state secrets doctrine. So it was an example of a chill due to surveillance programs that were too secretive under national security doctrine, and they couldn't be challenged in open court. So even if you get over that hurdle, even with concrete evidence, courts are really skeptical of these kinds of claims.
Evelyn, anything you want to add from your research?
Yeah, I'd love to jump in and say, so I think the kind of empirical demonstration that John has done, and that and also the the evidence that the witnesses gave in AAUP v. Rubio, I'm like extremely grateful for that evidence, and both as a First Amendment scholar, but also as a non-citizen in this country, extremely grateful to those witnesses and to all of you for bringing that case. And I think the survey data that Stacy was talking about is all extremely valuable and extremely important in creating a litigation record and a historical record of what is going on. But I actually think that the role that this kind of evidence or what evidentiary standard we should have in doctrinally is actually pretty complicated. And so I sort of want to talk about that a little bit. When the Warren Court developed this or sort of took the seeds of this doctrine, that it existed before the Warren Court, but it really came in this period, it was pretty non-empirical. It was pretty loosey-goosey and vibes-based, and just recognizing this intuition that the court had, that I think we all have, exactly as John was saying, it's a very natural social instinct that you have. Like, chill is something that I think everyone can understand. Is happening and would happen in the face of certain kinds of government power. And the court was sort of really sensitive to this idea. And while, there was actually, and sometimes it didn't need evidence at all. It was just this intuition that it was operating on the basis of. And it's also, what developed these sort of exceptional third-party standing doctrines, this fundamental recognition that if you are too scared to speak, you're going to be too scared to sue. And so overbreadth doctrine was a recognition of this. You can sue, you can bring a First Amendment claim on behalf of people not before the court to vindicate their rights in order to ensure that these First Amendment claims get heard. And similarly, in some of the jawboning cases, in Bantam Books, we see the court having a very broad conception of standing to ensure that the claims make it to court. Because otherwise, just the social dynamics and the litigation dynamics mean that the right people won't be challenging these laws. And so while I think it is really important to be looking for new ways to demonstrate chill and to substantiate chill and to bring those claims to court, I think in some ways, I want to take a step back and say, like, the point of chilling effects doctrine is to be like this realist doctrine, to recognize and understand how government power operates in the world, and to not be too formalist about, like, here is the evidence and here is the chill and therefore we vindicate it. Because in some ways you're never going to be able to demonstrate the full extent of chill. That's the whole point. You can get at it sort of in certain ways, and you can show various aspects of it, but there's always going to be this missing piece. And I'm also not sure that the court, like this court even, is necessarily going to be extremely empirical about it. So AFP v. Bonta, for example, which I mentioned earlier, stunningly non-empirical claim that donors in California are going to be chilled by the requirement to disclose their donations to the Californian government. There was no evidence that anyone had been chilled. Other donors came forward and said, actually, we're really proud of our donations. Like, it's kind of something that we trumpet and talk about a lot, not a chilling, this requirement's not going to chill. And the court instead relied on this intuition that disclosure laws require, that are going to chill. And so I think the evidentiary piece is super important. I think if you're a litigator, of course, you want to marshal as much evidence as you possibly can. But I also think that making the argument from First Amendment values and first principles is also really important.
Yeah, I think that's a great point. It's also striking how often the court's intuition of what would be chilling lines up with what they personally would be chilled by versus, sort of a reasonable actor. Okay, so we've got a question or two that's come in through the Q&A. And the first one is from Nathan Matias, who is also a former Knight Institute visiting scholar, a colleague of all of ours, and also one of the speakers for our next webinar on studying chilling effects. So Nathan asks, several people have talked about a suite of government actions which accumulate into a wider environment of fear and silence. As a non-lawyer, I'm curious how important it is for litigators and courts to identify and trace each individual potential source of chill individually, versus addressing a wide set of interlocking practices together. Does anybody want to weigh in on that?
I'll take a stab. Well, this is obviously my bias as a First Amendment litigator, but I think it is really important to address each one individually, while keeping in mind the gestalt, right? So I think, one funny thing, and we kind of saw this play out in the Doc Society case, is that when the First Amendment rights against government retaliation for your speech, for example, or being detained for expressing a political opinion, are kind of well established and well recognized and taken for granted, the chill of a surveillance regime might be less easy to understand. And I think that was something we came up during the first Trump administration, where the courts maybe were a little bit skeptical of the fear of speaking out against the Trump administration online when you're applying for a visa, for example. I mean, now that fear is underscored by a threat that you'll be swept off the street and thrown into a prison. But I think for that reason, though, I mean, to kind of counteract the broader chill, like the big chill, as Evelyn puts it, I think you do need to establish that in each of these individual instances, it actually is unconstitutional for the government to be taking some action against you. I mean, they're taking these kind of exemplary actions with the intent to chill. That's what the court found in the AAUP v. Rubio case, for example. But it helps to say that these individual, direct actions of direct acts of censorship are unconstitutional, to just remind everyone that the government can't do this. And so, going forward, hopefully in sunny days, we will be less chilled by, a wayward glance. Not that that's what surveillance is, it's the opposite. But anyway, that's my response.
Thank you. Anybody else want to add to that? Or?
I can add just a little bit. I think that the general sense that people are being chilled by like gestures to everything is like a very difficult litigation problem right now, given sort of both traceability and redressability. And the struggle with, just to totally co-sign what Carrie said about needing to prove that every individual thing is itself unconstitutional, is that when it is a straw that broke the camel's back situation, you do have to prove that this straw is the straw that broke the camel's back, but then you also, for redressability purposes, need to prove that the camel would somehow get back up again if you remove that one straw. And that can be really challenging in an environment like this. But in some ways, I see it as a failure of imagination by courts at the remedies stage. And I've been very interested in reading the remedies briefing in the AAUP versus Rubio case, because one thing that's asked for is an injunction, not just sort of a set aside of this policy, but a larger injunction against doing this thing. And I wonder if the court is receptive to that, whether that would be a good solution to try to break out of some of the formalism that is making it so difficult to challenge one of many things that are all leading to the same result.
Great, thank you. So another person has asked, how much does a decent admissible survey cost? So I can answer a little bit of this myself, not the cost necessarily, but I've worked on surveys trying to measure chilling effects in several contexts. Once when I worked at PEN America years ago, and once when I was an advisor on a Knight Foundation survey having to do with student speech. And one thing I can say, I mean, first of all, if you want a survey that holds up, you need to work with a reputable firm that knows how to run these things, which itself is not cheap. But also, I really didn't know how hard it is to design a good survey, just at the level of the question wording, like the months of work that go into fine-tuning exactly how you are asking questions, what sorts of follow-ups you are asking, the order in which you place the questions, and then trying to interpret the results you get from that. Usually, if you're fielding it online, you are usually dealing with, either somebody choosing between a range of options, or if you ask open-ended questions, and you've got to wade through all of the responses you get to those. So I learned a lot in terms of how challenging it is to put together a solid survey that is methodologically sound. I just wanted to throw that out there if anyone else has additional thoughts in our last minute. Okay. Well, we are now at time. I just want to thank all of our amazing panelists. This was a great conversation, and thanks to all of you in the audience who are watching. It looks like we have about 60 people here, which is great. To learn more about the Institute's work, please visit our website, which is knightcolumbia.org, and sign up for our newsletter. We'll put a link to that in the chat. And then again, if you enjoyed this, if you found this interesting, please come back for the second webinar on studying chilling effects, which will be on December 10th at 12:30 p.m. Carrie, Evelyn, John, Stacy, thank you again. This was great. And thanks all of you. Have a great rest of your day.